Hello, everyone. My name is Amara Bailey, and I'm excited to be presenting to you all the case of the Health and Hospital Corporation of Marion County versus Talevski. This case was argued starting November 8th, 2022, and it was decided on June 8th, 2023. Alrighty, just to give you all a quick overview of the agenda, I will give an overview of the case. I will also talk about the standard that was used to decide to make the decision of how this case was held. I will also talk about the opinion of the court, the majority opinion, and then I will also discuss the concurring and the dissenting opinions too. So this is my favorite quote from the case. It says, "We have no doubt that HHC wishes Section 1983 said something else, but that is an appeal better directed to Congress." And I love this quote because it is talking about the Supreme Court's insight on HHC was arguing that because of history, this particular statute does not make sense to be brought to the court. But Congress is saying that, sometimes things change. So just to give a quick background, so in 2016, George Talevski, who had dementia, moved into Valparaiso Care and Rehabilitation's nursing home. And his family mentioned that before he moved in, he still had his independent abilities. He could still eat, he could still talk in English, he could still carry a conversation, but they noticed that his dementia was progressing. So they moved him into the nursing home so that he could get under better care. Unfortunately, Mr. Talevski's dementia significantly worsened due to VCR giving him 6 psychotropics. And VCR was saying that no, this is how dementia naturally progresses. But however, with his daughter having suspicions of otherwise, they got a physician involved and they were able to confirm the maltreatment being done by VCR. So the Talevskis then report VCR to the Indiana State Department of Health. And then VCR went on to say that, Mr. Talevski is harassing the staff, the female staff, and the female residents. So they made harassment allegations towards Mr. Talevski. And due to these allegations, they would send him to a nursing home 90 minutes away from VCR without talking to his family first. This happened twice and they let him back in. On the third time, though, they were trying to have a forced discharge without really letting his family know. And they found out later on, and that was an issue in itself. And so they reported VCR to the department again due to their unfair treatment to Mr. Talevski. So the lower courts, so Ivanka Talevski, who argued this case, invoked this case to the courts, brought a tort action against HHC under 42 U.S. Code Section 1983, citing FNHRA provisions due to maltreatment of Mr. Talevski. So in this, the district court grants HHC's request to dismiss the Talevski's complaints per U.S. Code Section 1983. Then the Seventh Circuit reverses the district court's decision due to FNHRA provisions. And then the petitioner HHC argues that FNHRA cannot be imposed through the spinning clause, and they bring their petition to the Supreme Court. So the Federal Nursing Home Reform Act protects against unnecessary chemical restraints. So these 6 psychotropics that Mr. Talevski did not need, this act protects against that maltreatment. And then the unstandardized discharges and transfers. So family members should know that their family member is being transferred before they transfer them. There are certain protocols that the act guarantees. So then the petitioner versus a respondent. So as I mentioned before, petitioner HHC says that the Federal Nursing Home Reform Act provisions cannot be enforced through Section 1983 due to history. So when this code was created, it was around the 1870s. And people weren't suing due to this act. So they were saying, since this has never been done before, why is it starting now? And then the respondent, Talevski, of course, argued otherwise. So the Gonzaga standard, so the Federal Nursing Home Reform Act, statutory provisions must unambiguously extend individual federal rights via Section 1983. So the court wanted to make sure that this standard that was influenced by Gonzaga versus Doe was being upheld, meaning that it's not that the Taleveskis are going to benefit from, this act just because it happened to fall under the focal point of what this standard protects. But this act actually had to create federal rights for this specific class of people, which is a nursing home residents. So the opinion of the court. So Justice Jackson delivered the opinion of the court with these other justices affirming, and the decision held was the invoked Federal Nursing Home Reform Act provisions by Talevski against HHC are enforceable under 42 U.S. Code Section 1983. So other opinions. So the concurring opinion, Gorsuch J questions whether the court's precedent ensures that spending power legislation, such as the provisions in the FNHRA, are secured against states and are consistent with the Constitution's anti-commandeering principle, meaning that the federal government cannot force states to follow laws based off of utilizing their resources and their personnel. And then Justice Barrett says that the Gonzaga standard is high and many federal statutes will not be able to adhere to it. But in this case, they are the exception almost, that they were able to adhere to this high standard. So the dissenting opinion. So Thomas J. wrote many pages about it, but in essence, he said that the spending conditions in the Federal Nursing Home Reform Act are not law, so they do not enforce rights via Section 1983. And then Alito J. agrees with the Gonzaga standard used to decide the court standing, but unsure how this standard applies to this case. And I really agree somewhat with Justice Alito, because the Federal Nursing Home Reform Act does provide actions such as enforcing penalties and even enforcing fines per day up to a $10,000 fine when a nursing home is not in compliance with the Act standards. So there were already private actions that were input into the Federal Nursing Home Reform Act. But since when the Taleveskis were reporting this and the department did not do anything, that is why it escalated so much. So thank you all. As I said, I do agree a little bit with Justice Alito. I think it's unfortunate that this case had to go to the Supreme Court level. I really believe that it could have been handled, at the county, state level, even if they were enforcing the provisions, the standards of the Federal Nursing Home Reform Act. But I do agree that the Taleveskis definitely definitely were deserving of their compensation. I definitely believe that they were deserving of the compensation due to the maltreatment that VCR caused them. Thank you so much for listening.